Hello, and welcome to today's training on simple estate planning. My name is Katherine Cochran. I am a consumer rights attorney here at the Legal Aid Center of Southern Nevada, and I work specifically under a grant for the Legal Service Fund program. The Legal Service Fund program is run by the Culinary and Bartender Workers Union and benefits members of those unions. Specifically, we provide representation in some immigration matters, IRS tip compliance, bankruptcy consultations, consumer issues, family law information, tenants' rights and evictions, sealing criminal records, wills, powers of attorney, and healthcare directives, which we will discuss today, and unemployment overpayments, specifically as they relate to the pandemic. So the Legal Service Fund was created to provide members with legal information, consultations, and sometimes full representation in these issues that I discussed. All legal services provided are free to members, free of charge. So you don't have to pay anything except perhaps a filing fee with a local government agency or with a court. If you think you may qualify and want to apply for our services, please contact us at 702-386-1550 or email us at lsf@lacsn.org. So broadly speaking, what is estate planning? It's planning for the transfer of assets after your death, but it's also planning for your health and preservation of assets in your later years. I think possibly everyone here today has had a family member who passed away, and other family members had to scramble and figure out what was going on with the home. What were the plans for burial? Who received a car or bank account after their passing? So what assets are generally included in your estate? If you own a home, that home is included. If you own a vehicle, your vehicle is included. Any bank accounts or other financial instruments, such as investments, 401k, life insurance, some annuities, etc. Now, anything not already mentioned falls into what's known as your residual estate. This includes kind of everything else: your clothing, your furniture, your personal effects, your dishes, any artwork, any jewelry. Now, a lot of people just don't plan for what happens after they pass away. That's not necessarily a bad thing. It's just, we as humans don't want to think about our death. We don't want to think about our family living after we pass away. But if you've amassed any sort of wealth during your lifetime, whether that's a home or land or a significant retirement account, you want to make sure that that passes on to your loved ones kind of pain-free. Now, if you don't plan, everything has to go through probate. Now, probate is the court process by which a court changes ownership of property from the deceased person to their heirs. This is specifically as it relates to titled property. So a home or land has title. A car has title. Bank accounts, whether you realize it or not, are titled. And as long as it's titled in that deceased person's name, the living people who are left can't really do anything with it. It's difficult to sell a home if you don't own title. It's difficult to sell a car if you don't own title. You can't really access a bank account if your name's not on the bank account. So probate is the process to change ownership to someone who is alive. Now, ultimately, we want to avoid probate because probate can be complicated, expensive, and lengthy. There are quite a few probate attorneys here in Las Vegas. They make a pretty penny. They do a pretty good job. But by and large, probate's not really something that you can do on your own. You may be able to if it's a smaller estate, but I can promise you it's not going to be the easiest thing you do. It can be complicated because the rules are pretty complicated. It can be expensive because probate courts generally require that a bond be placed with a court prior to a case being opened. And it can be lengthy because there are several notice requirements of probate. You have to notice all the potential heirs or potential beneficiaries, and then wait for them to respond. So probate can drag on for a couple months. Some estates, maybe some famous estates you've heard of, Prince comes to mind, take years to probate before a final court order came out saying that one person owned this, another person owned that. So if you find yourself in a situation where you need to probate a loved one's estate, but you need to access the liquid cash soon, or you need to sell a home soon, probate might hold that up. So ultimately, we want to avoid probate. But all is not lost, because there are several ways you can avoid probate. So when you opened a bank account, your banker probably asked you to name a beneficiary for your bank account. This would also be known as a POD, or payable on death. Now, a beneficiary to your bank account, after your passing, they would only need to go into the bank with a copy of the death certificate, fill out any of the bank's, attendant paperwork, and then pretty quickly, the bank can change ownership of that bank account to that new person. This is really, really useful because, say you have a large savings account, your loved ones can access that after your passing to take care of your burial instructions. Now, if you don't already have a beneficiary on your bank account, I advise you to go and get that named pretty quickly. All you need to do is go into your bank, talk to your banker, and say that you want to add a beneficiary or a POD designation. The same goes for your retirement accounts, investment accounts, and life insurance. Life insurance is pretty self-explanatory. Everyone knows that there's a beneficiary to life insurance. I purchased life insurance on myself, and I designate my brother to receive that. He's got a lot of student loans. I'm sure he's going to be grateful for that, but hopefully I never need to use it. Now, retirement and investment accounts, they won't have POD designations. They will instead have TOD, or transfer on death designations, also known as beneficiary designations. Some retirement accounts won't allow you to name a beneficiary. So a single life annuity, for example, is meant to pay out during your life only. Now, you can have a joint and survivor annuity that is designed to pay out during your life and the life of someone else. That other person is the beneficiary, or the TOD designated person on that joint survivor annuity. Investment accounts, those are actually pretty useful to have a beneficiary on, because when you pass, investments, homes, etc., if you leave that to a beneficiary, your beneficiary generally receives what's known as a step-up in basis. Step-up in basis means that their initial investment then becomes the market value at transfer. So they aren't taxed on that capital gain. Now, if any of this is confusing, I myself am not a financial advisor. I do recommend that you speak to a financial advisor about what a step-up in basis is, and if your beneficiaries might be able to benefit from it. But in general, attorneys do recommend that you take some preliminary planning steps and designate beneficiaries on your bank accounts, retirement accounts, investment accounts, and life insurance. Now, here in Nevada, you can also add a beneficiary to your vehicle's title. If your vehicle is already paid off, you can go to the Nevada DMV's website, download a title beneficiary form, fill that out, send it up to Carson City with $20, and they will send you back a new title that lists your beneficiary on it. That way, after you pass away, your family member, your beneficiary, they simply need to go to the DMV with a copy of the title beneficiary, a copy of your death certificate, and maybe fill out a form with the DMV. The DMV will go ahead and switch title. No need to go through the probate process. Similarly, here in Nevada, you can also file what's known as a deed upon death for your home. Now, I've lived in a couple states here in the US. I have never seen this before, so I think it's unique to really only a handful of states. I know Texas has it, Minnesota, Nevada has it. So a deed upon death is essentially just a form that you fill out, or rather, we draft it. You sign it, get it notarized, file it with the county assessor in your county, and it tells the state, I, so-and-so, own this property, and I wish to leave this property to someone else after I pass away. Now, a deed upon death does not change ownership rights while you are alive. For example, if I own a home and file a deed upon death, giving the home to my 2 children after I pass away, my children cannot then go and sell the home out from under me in 20 years. I still own the home. I can still decide to sell it or keep it, split it, rent it out, whatever. So while you are alive, a deed upon death does not change ownership rights. After you pass away, however, your family members would then take an affidavit, which our office can provide, along with a copy of your death certificate to the county assessor's office. The county assessor will then pull the deed upon death out of their internal file, compare the two, the affidavit, the death certificate, against the deed upon death, verify that information, and once they've decided that the person who died is the person who's named on the initial deed upon death, then they will switch title ownership into the beneficiaries' names. Pretty simple process. It's a $42 filing fee right now with the Clark County Assessor, and you can avoid probate on your home. This is really, really, really beneficial to a lot of our clients. So if you own a home with a spouse, here in Nevada, you own it as joint tenants with rights of survivorship. You might also see this listed somewhere as JTWROS. So joint tenants with rights of survivorship means that once one spouse passes away, the property automatically is owned in full by the other spouse. Now, that other spouse can devise it or sell it, give it to someone else if they want, but generally they give it to the children. So if you own a home as joint tenants with rights of survivorship, so most married couples, you can go ahead and deed upon death your property to your children. So here on the screen, I have gone ahead and posted up a sample deed upon death that I drafted. So John and Mary Smith, together as the grantors, hereby convey to Joe Smith, grantee, an unmarried man, and Anna Smith, an unmarried woman, as their sole and separate property, effective on the death of the last surviving of the grantors, all the grantors' rights in a property commonly known as 123 Meadow Lane. So here, John and Mary have decided that they are going to give their property to Joe and Anna at their passing. Now, Joe and Anna are probably children when this is drafted, and therefore you'd have to plan for someone to hold the property in trust if John and Mary passed before Joe and Anna were the age of majority or 18. But if they're older, if they're adults, Joe and Anna would assume this property as adults. Now, if Joe and Anna are married at the time to other people, of course, are married at the time that they receive this property from their parents, then they would actually hold this property outside of the marital estate. They have to be very, very, very careful that they do not commingle this property or the benefit of this property with any marital funds, but they can keep this outside of the marital estate, and therefore it would not be subject to community property generally. Now, if Joe and Anna are married to other people at this time, and they think that divorce may be on the horizon, once they receive this property, keep the property separate from the marital estate and immediately contact an attorney, because that attorney will need to give you more details. But I digress. Back to the original. So Joe and Anna would receive this property at their parents' passing. At this time, they can buy each other out. So say Joe wants to buy out Anna's share. He would go get a valuation of the property, pay Anna 50%. Now Joe owns it free and clear. He'd have to get it retitled. It would be a transfer of value. So there's a taxable event there, but Joe can have it. Or Joe and Anna can sell the property and split the proceeds. That's something that a lot of children do. Or Joe decides that he wants to go travel the world and Anna wants to live there. Anna can live there and pay Joe rent. After John and Mary pass away, Joe and Anna can do whatever they want with the property. So after we've done all this planning to avoid probate, what do you need a will for? Do you need a will? Short answer, yes. We're going to go ahead and do all this planning to avoid probate now, but hopefully you're going to live for another 50 years, and things can change during that 50 years. You might have more children. You might open another bank account. You might buy a new life insurance policy. You might buy another home. You might sell your home. In any of those situations, your estate might need to go through probate to tie up those loose ends. So we do recommend that you have a will, because essentially that will is the instruction manual to the court of what you want to happen. Without that instruction manual, the judge or the court needs to do some heavy lifting. They have to trace down all potential errors. They have, an attorney would have to then publish, notice of the probate and notice of an estate, et cetera, et cetera. And it can be a little difficult. However, if you have a will, you've already named all of your assets. You've already named all of your potential heirs and beneficiaries. And then you've also included a residual clause. So say I have a will. At the time of my will, I own one home. 50 years go by, I've bought another home. So I own two homes. And that second home is not included in my will. What do I do? Well, all of our wills include a residual clause. Residual clause is everything not already named that I own at the time of my passing. I want to go to person A or person B or person A and B together. That second home would fall into the residual portion of the estate. So I like to think of it as the catch-all. So the will still provides the court instructions on what you want to happen. Additionally, the wills that our office prepares include a clause that waive two important things. First is our wills waive the bond requirement, which I'll explain in a moment, and they waive the inventory requirement. So the bond is essentially a chunk of money that your family members will have to deposit with the court at the outset of probate. Think of it like an insurance policy. If the court messes up at any point in the process and accidentally gives a piece of property to someone they should not have given it to, say a false heir or someone that you have already disinherited, then the bond pays out the value of that property to the correct beneficiary or the correct heir. Now, the bond here in Clark County is typically valued at about 6% of the estimated value of the estate. So think of your home, your retirement accounts, your bank accounts, your insurance. Group all of that together, that's the value of your estate. Now take 6% of that. That's a large chunk of change for your family to have to come up with just to straighten out title at the end of, after you've passed away. So our wills waive that bond requirement because, again, you've already given your instructions to the court in the form of a will. The court can't really mess it up because you've already told the court what you want to happen. So our wills waive the bond requirement. The second thing that our wills waive are the inventory requirement. The inventory requirement is a requirement that's at the outset of probate, and it requires that the beneficiaries submit to the court a list of everything owned in the deceased estate at the time of their passing. This can include the large things, so your home, your car, your bank accounts, but it also includes everything else. Your clothing, the dishes in your cupboard, the food in your refrigerator, all of your jewelry, watches, artwork, etc. It can be a burdensome requirement for family. Say their parents have just passed away, now you have to go into their home and dig through everything and come up with a list of all of that. So, because again, you have a will naming all of your earthly items and a residual estate, which catches everything else, the court doesn't require an inventory. So again, you're going to try and plan to avoid probate, but should something happen that does send your estate through probate, a will makes everything a lot less expensive, a lot faster, and so much easier for your family members. So at the beginning of this presentation, I mentioned that there are really two parts to estate planning. One is the preservation and passing of assets after your death, but the other is the preservation of assets and health in later years. We can accomplish that with really three different documents. So the first is a financial power of attorney, the second is a healthcare power of attorney, and the third is an advance directive. A financial power of attorney is a document that gives someone else the power to make financial decisions on your behalf, should you so choose. This can be something that you execute today and give to your child to go run all of your financial errands, or it can be something that is springing. So it only comes into being or springs into being if two doctors say that you're unable to make those decisions. This empowers your agent to pay your bills, file your taxes, communicate with benefit programs such as Medicaid, the IRS, Social Security Administration, etc. They can manage your financial accounts, and should they need to, they can buy or sell a home for you. So let me talk about two situations where you might want a financial power of attorney. So say two people are married, but husband needs to travel outside the country for an extended period of time, say 3 months. But he and his wife have decided that during that 3 months, they also want to sell their home. Rather than schedule flights back and forth from this other country for him to be there for the signing appointment to sell the home, he can instead execute a financial power of attorney for a temporary, finite period and give his wife the power to sign on all of the sales contracts and execute that sale while he is abroad living his best life. That is one example of a kind of temporary financial power of attorney. Something more common and something we usually see people opt for instead is a springing financial power of attorney. A springing financial power of attorney says that the powers vested in the agent only spring into being, only come into being when the principal or the person drafting the financial power of attorney or the person owning the financial power of attorney is unable, as decided by a doctor, to make financial decisions on their own behalf. So an example here is my grandfather. So my grandfather suffered from Alzheimer's for the last 5 years of his life. Ultimately, he was pretty fine, but there were some financial decisions and financial things he was having trouble taking care of. He would forget to pay his bills. His taxes were late one year. It only got to the point where he tried to sell his home to his neighbor for about $5 that the family got a little concerned. Luckily, the neighbor knew my dad, called him up, said, "Look, I think your dad is having some trouble making financial decisions." So at that point, my dad stepped in and gained financial power of attorney over his father, my grandfather. He was able to safeguard all the property. He was able to pay the bills on time, file the taxes on time, make sure that my grandfather got all of his medical benefits from the VA, et cetera, et cetera. And when that home did need to be sold, he made sure that that home sold for fair market value. So similarly, a healthcare power of attorney does pretty much the same thing for your healthcare. There is no option to just randomly give healthcare power of attorney to another person. It's only a springing power. So it only springs into being if a doctor certifies that you are unable to make healthcare decisions on your own behalf. So this gives your agent the power to discuss your health with the doctor, sign you in and out of the hospital, make decisions about treatment and medication, and consent to treatment. Now, in our healthcare powers of attorney, we actually lay out a whole host of questions, and you get to go through and choose your answers. So you get to decide, if in this situation, what do I want my treatment to look like? For example, if I'm in a coma, do I want to be allowed to live in that coma, or do I want to be allowed to pass naturally? If in a lot of pain, do I want to receive pain medication? You get to designate what those decisions look like, and your agent gets to help you make them and execute on those decisions. This also allows your agent to discuss your health with a doctor. So if you are maybe really confused and you don't quite understand your health, your agent can help you learn more. If you're in a lot of pain and on medications that make decisions really confusing or difficult for you to make, your agent can help you make those. I think a healthcare power of attorney is really, really useful because you, again, go out and trace your healthcare decisions before the fact. That way, your agent doesn't have to do a lot of the emotional heavy lifting. They don't have to decide What did mom want? What did dad want? Did anyone have this conversation with mom or dad about their treatment? Well, it's a moot point. You have a document that says, I want this to happen, and your agent gets to help you through that. Now, healthcare power of attorney can be good for several years. Again, my grandfather had Alzheimer's for quite a while, and my dad had a healthcare power of attorney over him. He was able to find a good skilled nursing facility for my grandfather when, care for him at home became too much for myself and my mom. He was able to discuss his healthcare with his doctors. He was able to discuss his healthcare with the VA and make those really hard decisions. But he'd also had a really good discussion with his father before this and knew what his father wanted to happen. Now, an advance directive is similar to a healthcare power of attorney, but I mentioned earlier that healthcare power of attorney can be good for several years, or you can use it for several years. An advance directive is really only used for a finite period of time, and that is the final days or weeks of your life. Now, we can help you draft that, and it gives someone else the ability to make those really hard decisions for you. Now, there's 4 questions that we include in our advance directive, and they're pretty straightforward. What do you want to happen at the end of your life? And an advance directive is really used when you cannot communicate your wishes or your needs to your doctor. So if you're unable to communicate with your agent will then make decisions in line with your answers to these 4 questions. Do you want to be allowed to pass away naturally or receive life-prolonging treatment? Do you want to remain in a coma? If your doctor doesn't think that treatment will be helpful, do you still want to receive that treatment? Do you want to receive food and water? All of these things can be really, really emotional decisions for your family members to make at the 11th hour. When you're in pain, when you're at the end of your life, your family is thinking emotionally, and they may want you to stay around as long as possible. But maybe this is something you've given a lot of thought to, and you have a very definitive idea of what you want to happen. So this takes that emotional burden off of your family members and tells the doctors exactly what you want to happen. So I recommend the financial power of attorney as a way to preserve financial assets in your later years, and the healthcare power of attorney and advance directive to allow you to control your healthcare choices when you're really unable to make those choices in the moment. So this concludes our presentation on simple estate planning. Now, if you are a qualified member of the union and you're interested in our services, we can help you with that deed upon death, that last will and testament, the financial power of attorney, the healthcare power of attorney, and the advance directive, if you're so interested. Feel free to call our office. Our intake number is 702-386-1550. Our advocates will verify your eligibility through Zenith and then schedule an initial consult to discuss your concerns and needs. It may be that you don't need any of those powers of attorney, or you don't want them. It may be that you don't own a home, so you don't need a deed upon death, but you still want to safeguard your assets and make probate a little bit easier for your family. So last will and testament and those powers of attorney might be useful for you. Additionally, the majority of our advocates and our legal assistant are all bilingual, so please don't consider language as a barrier to services. If you do speak Spanish specifically, please, we welcome you with open arms. Come see us. We will work with you and make sure that we meet your needs. Now, this is an online presentation. So at this point in the presentation, I would generally welcome questions from the audience, but as we are online, I'm going to ask that you email us at lsf@lacsn.org. Thank you for your time.